Hello everyone, a very good evening. Welcome to Oliveboard. This is the CAIIB Foundation July 2025 BRBL paper, and today we are going to cover the unit 14 from module B. This unit is the creation, registration and satisfaction of charges. We have already studied in the previous two chapters the mortgages and other types of charges like appropriation, assignment. I hope everything is clear from that. Today we are going to study the meaning of charge, the registration of charge, the different types of charges, what happens if you don't get the charge registered, and so on. All right, so let us begin with unit 14. With this, we are going to finish the module B and start with module C from the next session. The module A and the other units have already been completed and they are on the YouTube channel. If you haven't yet seen them, please make sure that you watch them as well because they're very important when you are kickstarting your preparation. Now let us start. First, we will see the meaning of a charge. First, charge has been defined in which act? So it is defined in the section 2 subsection 16 of the Companies Act 2013. Whenever the definition or we will say the act is mentioned, we need to remember it. Then a charge means an interest or a lien created on the property or assets of a company or any of its undertakings or both as security and includes a mortgage. So we already know that whenever a borrower takes a loan from a creditor or let's say a bank in our case, then in return of this loan they're giving this security as an interest to the bank that the bank have an interest on. They can sell it or they can recover their loan in case of non-repayment or in case of default. Now what will happen, why this concept of charge is given? If let's say the borrower takes this security, if they had not given the possession and they had only created let's say a mortgage with a deposit of title deeds, they can again get it secure, they can again get the loan on the same security or the same property from another lender, let's say from bank A, then bank B, and then bank C, right? Now in the situation if the borrower defaults on the payment of the loan, so all of these lenders can come and ask for the repayment. Now who will be repaid when the security is brought to the market? This question might arise. So to solve this situation or to ease this question, what was done, the concept of charge and getting it registered was created. So doesn't matter when, but whenever the security is taken for the loan that is given by the bank, they have to get it registered. And when a charge is registered, it doesn't matter if the borrower gets it, the property, gives it for security to another bank or another lender. If the charge has been registered, then the priority of the repayment when it is marketed will be to the creditor who has gotten it registered, right? So this is the main aim of getting a charge registered. All right, so charge includes the meaning we have already seen, either an interest or lien created by the property. Now the most important topic of this chapter, it is mandatory for every company to register with the registrar of companies, the ROC, specific charges that are created by it on its asset as well as modification of the charge or its satisfaction. So three things are there. There are different forms that have to be filled and submitted to the ROC. When first the charge is being registered, it is the responsibility of the company to get it registered, company who is taking the loan. But there are provisions under this as well, that if the company has not gotten the charge registered, then the bank can also get it registered. If they however do not, then again they will not get the priority in time of the repayment when the company makes a default. Second, for any change, if let's say the interest rate change is there or the due payment change is there, there is a change in the contract deed between the creditor and the debtor. And finally, when the charge has been satisfied or the loan has been repaid, then also a form has to be submitted. And all the companies, whenever they are taking a loan, whenever they are creating a charge on their assets or their property, they have to get it registered with the ROC. This ROC, when they register the charge, they are going to give a certificate, and it is believed that the charge is registered in the public notice. Public notice. Now, if we want to check whether a company has created a charge or already taken a loan on a particular asset or property, we can go to the MCA website. There's a portal for checking the charge, and we have to see through that. If, however, any bank, they do not make this clarification, or the creditor, they do not check whether the property is encumbered or not, then it will be their fault, because once the ROC gets the charge registered, they give a certificate. They believe that now this is in the public knowledge. The notice is being provided to the public that the charge has been registered. So the registration of charge provides a notice to the public contemplating to give credit to the corporation on how far the property of the company is encumbered. So now it is the responsibility of the creditor to check on the MCA website. Then, all right. Earlier in the uh, earlier law of the company law, it was given certain charges were mentioned that had to be required to be filed with the ROC, like charge for the purpose of securing any issue of debentures or the share capital or the book debts of the company. This act said that the 1956 Companies Act said that all the charges were not required to be filed with the ROC. But the Companies Act has said that now all the types of charges are required to be registered with ROC within the stipulated time period, irrespective of whether the charge is created within or outside India, whether it is on the property or assets or any of its undertakings, whether the charge is tangible or intangible, fixed or floating, it is situated in India or outside India. All the types of charges have to be registered with the ROC. This change has been made with the new law. Right, so all the charges, however, there are three exceptions. The charges not requiring registration are corporate guarantee, any charge arising due to the operation of some specific law, or a hundi, which is a negotiable instrument. Other than that, all the charges will have to be registered. This is given under the Companies Act 2013. All right. So if a question is asked which of the following is not required to be registered, you know it is only three. Other than that, all the types of charges have to be registered. Then we have the two types of charges. Two types of charges. When, let's say, a particular company, they have stored their produce or they've stored their goods in a warehouse. In a warehouse, and then a part of the warehouse or a part of their total inventory they're keeping as security. So the bank or the creditor is going to have the interest only on the specific property or the properties of the company which are provided as the security. So the fixed charge is also known as a specific charge. It extends over a specific property or properties of the company. So when a particular or specific property is given as a security for a loan, then it is known as the fixed charge, only on the property which is given as a loan. Floating charge, however, means it is general. So on all the property of the company, the floating charge is created. It is not specific. So it floats over the present and the future property of the company, right? Or it does not restrict the company. The company can assign the property to a third person as well by a way of sale or security, right? So these are the two charges, the fixed charge and the floating charge. So fixed charge is only on some specific property, whereas the floating charge, it floats over all of the property, and the company can still buy or sell. They can carry on with their normal ordinary course of business. They can deal with the property in any manner until the charge attaches, right? Until the charge attaches. Now, there are certain circumstances in which this floating charge can get crystallized or convert into a fixed charge. So, when does a floating charge become a fixed charge or a crystallized or attached charge? When a debtor company ceases to carry on the business or goes into liquidation, the company is winding up, or the debenture holder or the creditor in whose favor the charge is created intervenes by getting a receiver, then the floating charge will now turn into a fixed charge. And the floating charge may also crystallize on the happening of an event specified. If, let's say, in the starting of the charge deed it was mentioned that, let's say, after a year this floating charge will be converted into a fixed charge, it will be crystallized, then also it will change. What will be the impact of a floating charge becoming a fixed charge? So when a floating charge upon all the property or assets of the company becomes fixed, it constitutes a charge upon the property or assets. Now all the properties, when on all the properties the floating charge was created and now it is getting crystallized. So now on all the property the fixed charge will apply. Then all the property that is belonging to the company will come under the fixed charge. What will be the benefit for the creditor? It has the priority over the subsequent equitable charges or over the unsecured creditors. Now let me just clarify it once. Whenever let's say the borrower had taken loan from five different creditors A, B, C, D and E. All right, but the charge was created on the same property, let's say a house. All right, not let's say a house, let's say on the property of the company that is kept in the warehouse. All right, on the warehouse, but then the charge was registered only by the third third creditor or the third bank, or they had given the charge of a fixed nature. Then when the property is sold in the market under the SARFAESI or IBC, then the money that will be generated will be first used to pay off the debt to the third creditor who had gotten the charge registered. So this creditor who got the charge registered will have the priority over the subsequent equitable charges or over the unsecured creditors. So now C will become the secured creditor as soon as the charge is registered with the ROC. When we study the SARFAESI Act, we will see the sequence. There are 8 to 9 points. The first, the secured creditor will be paid from the amount that is generated from the market. Then the unsecured credit, then the payment will be made to the officers that undertook the securitization. Payments will be made to the employees of the company. Then any charges will be paid. And then on the 8th or 9th or 7th number, there is the payment will be made to the unsecured creditor, right? So whenever a fixed charge is created or a charge is registered, this creditor will become the secured creditor and they will get priority over all the other subsequent equitable charges or over the unsecured creditors. So this is the whole concept of getting the charge registered. That is why the charge is registered, right? So any subsequent registration of charge will not hold any prejudice to the first person or the first entity that got the charge registered. So doesn't matter even if the third or the fourth person is getting the charge registered, whenever the charge is registered first will get the priority. Now, an ordinance was made in 2018. Before this ordinance, the charges that were created or modified, they had to be registered within a period of 30 days with normal fees, then beyond 30 days to 300 days with normal and additional fees, then again additional 6 months were given, right? So these terms were very, we'll say, uh, not up to the mark, or we'll say that the registration of charge was not compulsory because these were very flexible, ranging up to 1 year, 6 months and so on. But then the ordinance that was created after 2nd November 2018, the days have been fixed. Within 30 days of the charge creation or modification, if the charge is registered with the ROC, then normal fees will be paid after 30 days, but within 60 days if the charge is created. So 30 plus 30 days, normal fees plus some additional fees. After 60 days, but within 120 days, another 60 days are given. normal fees. But now when this amounts to 120 days, the charge cannot be registered. This was not there in the previous or before the ordinance in 2018, right? The charge could be created beyond these days as well. But now, after the ordinance, starting from 2nd November 2018, the charge can be registered only within 120 days, not beyond that. All right. So this provision is there. This is very important, the change that has been made. So if you are asked a question, the charge cannot be registered after how many days? It is 120 days. It is 120 days. All right. Then what else? Now here I have mentioned the different forms which have to be submitted to the ROC whenever we are getting the charge registered, modified, or when the charge is satisfied. So CHD1 is for the application for the registration of creation. CHD2 is for the certificate which is given by the ROC. Then 3 for the certificate of registration and modification, the particulars, memorandum, notice of appointment. Now here, what is important for the application for any delay? If there is a delay of the creation of the charge or getting it registered, then the company will have to submit it with the form 10, right? So the application for dealer has to be made with the registrar in form number 10, supported by a declaration of why such dealing was there, or such delay is not going to adversely affect the rights of any other creditors of the company. All of these things are there. Another very important provision which is given is that if the company has not gotten the charge registered, then what will happen? The ROC says that the banks or the creditor can also get the charge registered, and if any fees is paid, because fees is paid for the registration of the charges, it will be borne by the company. They can get it recovered from the company. All right. So this provision is also there. All right. So that is all. We have completed the unit 14, and all of these provisions are the most important ones. So whenever you read this chapter, make sure that you uh, write down or you take note of the time period within which the charge has to be registered, or the procedure, or with whom the charge is to be registered, the effect of getting the charge registered, or the priority, right? What is the meaning of the secured creditor? Now if you want to study, if you want to join the CAIIB selection batch for the June July 2025, which is an all-in-one course, you can do so, in which you will get the study material, live classes for all the 4 papers. So under one batch you will get all the 4 papers, plus you will also get elective paper test, case study, numerical based test, full sectional test covering the papers, downloadable study notes. And if you join the course before 19th January, then you will also get the Mahakumbh special pack, in which you will use the code SPL and get flat 49% off on your subscription. All right. So that is all for today. We have completed the module A and module B. In the next session, we will start with module C, and we will complete all the topics, all the units of the syllabus. So I will see you again. If you have any doubts, any queries, please let me know, and don't forget to subscribe to the channel so that you do not miss any of the updates. Thank you so much, and all the best for your preparation.